Hello, and welcome to Wills for Heroes volunteer training. My name is Alex Rogers. I am the pro bono clinics attorney for the North Carolina Bar Foundation, and I'm joined today by Samantha Gordon, who is one of our lead volunteers for the Wills for Heroes program. All right, so this Wills for Heroes clinic is a program of the North Carolina Bar Foundation. The NC Bar Foundation is the charitable arm of the North Carolina Bar Association and exemplifies the legal profession's commitment to service. Through the foundation, pro bono and public service programs, and our endowment, we unite the talent and the generosity of our profession to be a power of greater good for the people of North Carolina. Our foundation's programs and our endowment funding priorities all are guided by the foundation's values, which are access to justice, service through the profession, civic education, and professionalism. These values define for us what it means to use our skills, our means, and all of our professional resources to serve North Carolina communities statewide. The foundation lives out its mission and values by creating opportunities for lawyers, paralegals, and law students to serve. The agenda for today. So this training will explain how the virtual Wills for Heroes clinic will work and provide an overview of the documents offered through this clinic, which are the last will and testament, the healthcare power of attorney, and the durable power of attorney. Finally, we will walk through the app designed to guide you through the client interview and generate documents. The run of show for the clinic. So as we mentioned in your orientation email, we are implementing a new format for our Wills for Heroes clinics that involves morning meetings with clients via Zoom to draft the documents, and drop-in hours the following day for clients to have their documents notarized. Clients do not have specific appointment times to sign and notarize. They are able to drop in when it fits their schedule. All attorney volunteers will be made co-hosts of the Zoom meeting once on the day of the clinic. As a co-host, we ask that you please do not admit anyone to the meeting. We have Bar Foundation staff who will coordinate letting clients into the meeting. Bar Foundation staff will also direct you to a breakout room where you'll meet with your client or clients. Once you're in the breakout room, you can start the interview using the Wills for Hero app right away. If you have a question at any point, you have three options for asking for help. One, you can click the Ask for Help button in your Zoom breakout room, and we will have an estate planning expert join your Zoom breakout room with you and your client. Two, you can click the blue Leave Room button, which will return you to the main waiting room, where we will have our Wills for Heroes estate planning expert volunteers there to help answer your question. Or three, you can text me, Alex Rogers, at 919-360-5356. Again, that phone number is 919-360-5356, and I will be able to direct additional assistance to you. Once you are finished with the interview, please review the Word documents while the client is still in the video conference to be sure the personal information is correct. Once you have reviewed the document, the clients can log off. We ask that you do a final review of the document and correct any formatting errors like page spacing, and we ask that you ensure the notary blocks are all on single pages. Once you've completed your task, please email the reviewed documents to wfh@ncbar.org. That's wfh@ncbar.org. These instructions are included in the app. Please include your client or clients' names in the subject line of the email. When you send the completed documents to the Wills for Heroes email address, wfh@ncbar.org, please feel free to include any notes that may help the afternoon document review attorneys in their meetings with clients. In particular, if your clients complete anything less than all three sets of documents, please note that in your email so that we are not unnecessarily waiting on a document. Before you log off, please return to the waiting room so that we can check to make sure your documents were received and to thank you again for your service today. The Wills for Heroes app. So we will be using our Wills for Heroes app to conduct client interviews and generate the client's documents. The app walks you through each document, providing fields for you to type in or select the information provided by the client. The app then generates Word versions of the documents, which you will download for review. The app saves the documents, and you can edit the documents within the app. After we review the substantive piece of training, we will walk through the app. Okay, so finally, malpractice coverage for volunteers. The Bar Foundation provides malpractice insurance coverage for your service as a volunteer in today's clinic. The documents in today's clinic are form documents. The wills are from the BB&T manual, and both the power of attorneys are statutory. Our malpractice coverage requires us to remain within the terms of the forms and not redraft to meet any unique client needs. In the event that a client has wants or needs outside of the scope of the clinic and the forms provided, please direct them to the NCBA Lawyer Referral Service, which can be reached at 919-677-8574. All right, I am going to now pass this on to Samantha to cover the 3 legal documents.
Awesome, thank you, Alex. I can't share.
Try now.
There we go. Awesome. Awesome. All right. We are getting there. And we are there. All right. So I am Samantha Gordon. I'm going to be covering the substantive part of Wills for Heroes. So we are doing 3 legal documents today. We are doing the will, the healthcare power of attorney, and the financial power of attorney. The financial power of attorney will be immediately effective today. That's the only power of attorney that we do offer. So if the client does not feel comfortable with that, they can do the healthcare power of attorney and the will, but that is the power of attorney that we offer through this program. So we just want to make sure, that through this program, we offer simple wills. We offer a simple healthcare power of attorney, and we offer a simple power of attorney. Like I said, clients can select all of the documents, or if they feel like they only want to do maybe 1 or 2, they have the option to do that. But we definitely highly recommend that the clients do all 3 of them, because that will avoid any timely or costly court-related procedures. So the documents are what they are. The reason why we have this slide is because the documents were specifically drafted the way that they were to provide simple estate planning documents to first responders through this program. So they should not be altered. Volunteers should not offer or suggest drafting the documents in a different manner than what we have through the act. We understand that there are different ways to draft estate planning documents, and some of you may be estate planning attorneys, but the documents that we have are what they are, and this is what we offer the clients through Wills for Heroes. So the first document we're going to do is the will and testament. So a will is a legal document that indicates a testator's directions for distributing their assets after their death. In the case that a testator has children or minor children, a will may also provide for the creation of a trust or the appointment of a guardian. In this clinic, we only provide simple wills, as I stated before. There are 5 versions to choose from through the act. So the clients have been provided information to help them select which will apply for their family structure or how they wish to distribute their assets. Still, it's an important and potentially complicated decision, so clients may have questions about which option to select. It's essential that you can get an accurate picture of who is involved, especially if there is a legal spouse, even if they are separated or estranged, because there are special protections for spouses under the law in North Carolina, which I'll explain in the next couple of slides. So we just want to ensure that when the client is telling you what type of will they want, we're picking the correct will. Ideally, if you're working with a couple, you want both wills to mirror each other. So that means you want the wills to have the same outcome. So for example, everything goes to each other. And then if something were to happen to both of the spouses, then everything goes to their children or child. If the wills do not mirror each other, someone who was intended to be a part of the will could be left out. So that's why we want to make sure that spouses' wills are the same. We do not want to subject these wills to any type of litigation. So just remember that the documents are what they are. So there are 5 versions, and that's what's listed right here. So I'm going to go over those options for you guys. So option A is all to the spouse. This option is typically for a married couple who has adult kids, adult meaning 18 years of age or older. The language states everything goes to the spouse first, then in the event the spouse has predeceased the testator, everything will pass to the testator's issue. Issue means child or children by blood or adoption. I'm sure that you remember that from law school. This option is also for a married couple without children. So if the couple does not have children, just please leave the issue language and include that information in your email so that once we do look at the documents, we'll know we need to look at that part. That way, like I said, the reviewing attorney can make any necessary changes that we may need to make. We do understand that some volunteers may practice estate planning, as I said before, but we have estate planning volunteers who are specifically going to be reviewing these documents in the afternoon for any issues. So if any issues do come up, just please put down your email and the attorneys that we have to review the documents will be able to address those issues. If clients want to name any alternate beneficiaries after the spouse, please let us know during the meeting so that we can also discuss that. So again, that would be for a couple that does not have children, but maybe wants to include like their siblings if something has happened to both of them. Option B is going to be all to adult children and no spouse. So this will is for a client who is single and has adult children. Everything passes to the adult children equally. We cannot change distribution amounts. Assets will pass equally to the children. Again, these are simple documents. Changing distribution amounts can make things complicated. Option C, all to spouse, then children in trust. I'll discuss more of the trust options in the upcoming slide, but this will is for a married couple who has a minor child or minor children. Just keep in mind that both wills should have the same trustee and guardian. So the trustee is the person that handles the trust for the benefit of the children, and the guardian is the person that handles the well-being of the children. So you want to make sure that in both of the wills, each spouse has chosen the same person as the trustee and as the guardian. The trustee and the guardian can be two different people, but it needs to be the same in both of the spouses' wills. Option D, all to minor children in trust, no spouse. So this will is for a client who is not married, but has minor child or minor children. So keep in mind, if a client is divorced, they should understand that if they have joint custody with the other parent, that parent will likely be appointed as the legal guardian of that child or children, but they can name a guardian in the will as a suggestion to the court. So you just want to make sure that if that is your situation with one of your clients, you're explaining that to them. If you have a question, you can always pop back to us and we can answer that for you. Option E, all to named adult beneficiary or beneficiaries. This will is for a client who is not married and does not have children. So keep in mind that the beneficiaries for this should be adults. So if your client wants to leave everything to their 5-year-old niece, maybe it's an option to leave it to their sibling instead through this type of will. So let's go over some terms just for those of you that maybe do not practice estate planning, and we just want to go over some of what these terms mean. So these terms are for the people that are involved in the will. So the testator is our client or testatrix, that's for a female, the person who's making the will. So an executor is the person the client has selected to carry out their wishes in the will. So we suggest that if you are working with a couple, that the spouses name each other as their first executor, and then they can name a secondary executor. Trustees and guardians will only be named if the client has minor children. So please keep in mind, if you are dealing with a couple, that a spouse should not be named as the trustee, because the trust will only go into effect when something has happened to both spouses. So neither spouse should be named as a trustee. The trust will go into effect, like I said, if something has happened to both spouses. A trustee should be someone the client trusts and thinks is responsible, because the trusts that we have in these documents are discretionary trusts. That means it's within the trustee's discretion to handle the money as they see fit for the children. So you want to ensure that the person that the clients are naming as their trustee is someone they trust and can handle money well. The trustee is named if the children are under the age of 25 and the client chooses a will requiring a trust. So that would be option C and D that we have talked about. A guardian is only named if the children are under the age of 18. So trustees and guardians, as I said before, they do not need to be the same person, because sometimes someone is great with handling money and sometimes someone is great with handling the well-being of a person, but they are not good at doing both. So it's fine if they're different. You just need to make sure that the spouses choose the same person as the trustee and as the guardian in both of their documents. In case it comes up with your clients, we do not recommend naming a corporate executor or a trustee or a trusted advisor for these simple wills. There are hoops that need to be jumped through with financial institutions if you're naming a financial advisor, and it's just not something that we can provide through this program. Like I said, it's simple documents for simple estate plans. So now we can talk about revocation. So the interview script asks right away if the client has ever had a will, a power of attorney, or a healthcare power of attorney. If the client has previously executed a will, they will need to revoke it. So in North Carolina, a will can be revoked by destroying the document with the intent and purpose of revoking it. The client should do this. So I recommend to the client that they should do this. If there are copies, they should make all attempts to have them destroyed, such as they filed the will at the clerk's office, or they worked with the previous attorney and it's possible that the attorney has a copy at their office. Just making sure they're contacting the correct people to make sure all copies are destroyed. Although the will is revoked by destroying one properly executed copy with the intent to revoke, it's good practice, like I said, to destroy all copies. So you just want to make sure. Now, key information to explain to the client. So as mentioned before, and I will say it continuously throughout this presentation, the clinic only provides simple wills. The documents are what they are. The wills are specifically drafted the way that they are to provide simple wills to first responders through this program. They should not be altered. Please do not add in anything that you typically add in for practice or anything like that. Leave them as is. If there's issues, just let us know and then we can address them for you. These wills are not intended for people who have complex estate planning needs. So for example, if their estate exceeds $11 million, if the client has a special needs child that could require a special needs trust, which we don't offer through this program, or if the client has a blended family. If we have multiple children from different marriages, it can just be very difficult. We want to make sure that our client's wishes are being met. And with a blended family, it just can be very difficult to make sure that happens. Wills for Hero volunteer services are not recommended for clients who also want to create multi-generational wills. That means they want to leave assets to their child and their grandchildren at the same time. There's tax implications that go into that, and we want to avoid doing that. If any of these situations arise during your appointment, inform the client that you will not be able to provide a will through the clinic and offer to complete the other two documents. So if they can't do a will because for whatever reason their family dynamics do not allow them, they can still complete the power of attorney and the healthcare power of attorney. Those are equally as important to have. Advise the client to seek guidance of an estate planning attorney if they need something that's more complex than what we can offer through the program. So now we need to talk about spouses. So in North Carolina, the spouse has an automatic right of election unless there is a prenup or a postnup agreement, or the client has a separation agreement that waives their right to an elective share or the right to inherit. So what that means is that no matter what the will says, barring a prenup exception, the spouse gets a chance through probate to claim a certain percentage of the estate. This is even if the clients are separated or estranged. So if they're separated and they do not have a separation agreement, that spouse may still have the right to elect. Divorce, however, voids any gift made to a spouse in a will. If the couple is remarried, the gift clause in the will is revived. If the client and a spouse divorce and the client still wishes to make a gift to the spouse, the client will need a new will, naming the ex-spouse specifically as an adult named beneficiary. Suffice to say, advise the client to seek a new will if there's divorce or any major life circumstance changes. So now let's talk about trust. So option C and D, as I said earlier, involve the trust. The two wills, option C is leave all assets to a spouse, but if the spouse dies first, the trust provision in the will creates a trust if there are children or a child under the age of 25. Option D creates a trust for a child or children under 25 and does not provide for any gifts for the spouse. It's important to know the ages of your client's children. That's very key because we want to make sure that we are doing the proper option for the will. The age is set to 25 in all of the documents. I do understand that There's different ages that some people put in their documents, but for Wills for Heroes, we have set the age to 25. The reason why we set the age to 25, you can explain to the client if they do ask, is that a child may more than likely be more responsible at the age of 25 than they would be 18 or 21. So that's why we have it at the age of 25, that they cannot outright receive any assets from the trust until they reach the age of 25. 25 and under, the trustee is the one that's managing the money for them. So the class of people that are included in the trust is closed at the moment of the client's death. So for these wills, the class is all of the client's children living at the time of the client's death. The class also includes any issue of predeceased children. So these are the living descendants of that child. That would be like a grandchild. So I'm just going to give a simple example of what that means. So client has 2 children, Alex and Blake. Alex has 1 child, Claudia, and Alex dies before the client. When client dies, Blake is still alive and is 20. And Claudia, who's the grandchild, is 5. The trust would include Blake because he's a child that was alive at the time of the client's death and is under 25. And then Claudia would be included because she is the issue of Alex, who was the child that predeceased the client. So continuing with trust, we're not going to dive into the fine details of trust administration during this training because that would take all day, but a basic outline of how trusts for minor children are created through wills is offered in this clinic. So remember that when we say minor in terms of trust, we mean under the age of 25. So some clients may want to do option A, where it's spouse to adult children. If they think, their child is 23 and they're super responsible, they would just want everything to go outright to them. That could be an option. If they feel like they want to wait till they're 25, then maybe option C would be the best for them, and the money would be held in trust until they reach the age of 25. All of the assets the client leaves could be bank accounts, it could be a house. They go into one pot for all of the children or predeceased children's issue. The named trustee, who is eventually going to be appointed by the court, manages the assets. The trustee, like I said earlier, has the discretion to distribute the assets as they see fit. So you want to make sure that the trustee is someone that the client trusts and is good with money. Like I said earlier, once all the children reach the age of 25, the trustee then distributes the remaining trust property to the child or children. And that, we have this last slide. So trust. So we get this question enough where we added on this slide to make sure that we can provide this information to the client. So if they choose option C or D and they have any life insurance, or if they have any retirement accounts, they have beneficiary designations. So typically for beneficiary designations, you would want to have your spouse as your first beneficiary, and then you have a secondary beneficiary. If they've done option C or D, they do have the option to put right here in quotations, trust under will of, and then client's full name. So if we have me, Samantha Gordon, I made a will, I have a 3-year-old child, I chose option D. So trust under will of Samantha Evelyn Gordon. That's what that would look like for their secondary beneficiary. So if you do get that question, here's the slide for that. And then also you can always pop back in and ask us if you have any questions about that. So next we're going to do the healthcare power of attorney. So the healthcare power of attorney allows the client, known as the principal in this document, to name a healthcare agent and up to 2 successor agents to make healthcare decisions on their behalf. The healthcare power of attorney becomes effective when an attending physician has determined that the client is unable to make or communicate their own healthcare decisions. If the client is able to communicate their own healthcare decisions, the client is the one to make their own decisions, and the healthcare agent does not supersede them. It has come up in the past where clients are not sure who they'd want to name as their healthcare agent, which is totally understandable. Sometimes spouses are okay with naming each other, but they're not sure who to name as the successor. So that's okay. We still want them to have these documents in place, even if they're just naming each other. But you could say that, if they don't complete these documents with a successor agent and they just have each other listed and they're in a car accident together, who's going to make those decisions for them? We want to make sure that they're covered. So just kind of talk it out with them and make sure that they're fully informed and they're making the right decision for themselves. And really, as a first responder, this could be the most important document that they do make. So we just want to make sure that we get these documents for our clients. So some key information to explain to the client. The healthcare power of attorney gives an agent broad authority. It essentially gives the agent the full spectrum of power to make healthcare decisions. So this includes authorizing medical treatments, such as mental health treatments, selecting medical providers, firing medical providers, consenting to the admission in healthcare facilities. There are even a few powers that survive the principal's death. So this includes disposition of remains, consenting to an autopsy, donation of body or body parts to science, and the donation of organs. The principal can apply limitations to the general powers, but as it's written, the document authorizes all of those broad powers. The document does not provide space for a principal to give highly detailed descriptions of their wishes. So advise the client to discuss their wishes and values with the person that they have named as their agent, especially sensitive topics such as a natural death and life-sustaining measures. If they have any type of religious beliefs or anything like that, we can definitely have that included in the document, but anything that is super specific, we just want to make sure that they're having that discussion with their agent. And typically we're not going to include that in the document because it's just not meant to have super specific instructions. So some more key information. As mentioned, the healthcare power of attorney is only effective when a physician has rendered a decision that the principal is unable to make their own decisions. Incompetence is not a permanent condition. And when the patient regains their competence, the document is no longer effective. So for example, if the client goes into surgery, they're under anesthesia, they cannot make their own decisions, but when they come to and they can make their own decisions, the agent no longer is going to be making their decisions for them. The principal, our client, will start making their own decisions again. An important note, unlike the last will and testament, divorce has no impact on the healthcare power of attorney. So if a spouse is named as a healthcare power of attorney, that is still valid after divorce. So if the client divorces and they do not want their ex-spouse making their healthcare decisions, which they probably won't, they need to revoke the old healthcare power of attorney and put a new one in place. So making sure they understand that is key. So what are the healthcare agent's duties? So a healthcare agent does not have an affirmative duty to act when they are named healthcare agent in a healthcare power of attorney. So this means if a doctor calls them up, they can decline without any legal consequence. However, if the healthcare agent chooses to exercise any of the granted powers of this document, the agent must do so with due care to act in the principal's best interest and in accordance with any of the provisions of the document. For mental health treatment decisions, the standard is for the agent to make decisions according to how the agent believes the principal would act. So we do have living will provisions in the document. So the healthcare power of attorney can also include a living will provision. We do not offer a separate living will, which is also called an advance directive. A living will provision is a client's statement about whether he or she wants life-prolonging medical treatment if, to a high degree of medical certainty, a doctor determines that the principal is terminally ill and unlikely to recover, in a persistent vegetative state from which the principal is not likely to wake, or is suffering from severe dementia from which they will die in a short amount of time. So examples of life-prolonging measures are artificial nutrition or hydration and breathing tubes. No matter what a principal expresses as far as wishes to not receive life-prolonging measures, he or she will be made clean and comfortable according to medical standards. So it does say that their dignity will be maintained. This is one of the most weighty and possibly emotionally difficult decisions a client will make during the course of the interview. So take your time here, advise the client, and discuss the decisions and options that they do have. In the app, there is a prompt for adding limitations, and if the client wishes to make any type of limitations with regards to life-prolonging measures, you will need to add the limitation for the healthcare agent. So just some practice notes. The statutory form of the document defaults to having an attending or eligible physician to be the one who determines the client's competence. However, the document allows a client to name a specific physician if they would like to. Few clients want to do this, but if they seem like they want to, explain the drawbacks on this, and specifically The drawback would be if they named their primary care physician and something happens to them at 2 o'clock in the morning and they're at the hospital, the attending physician is likely the one that's going to be available to make a decision about competence rather than their primary care physician. So it may just be in their best interest to have the attending physician be allowed to have that authority to decide whether or not the client or the principal has competence. So another practice note, and this is kind of something that I talked about a little bit earlier, the document gives multiple opportunities for clients to provide specific limitations to the agent's general authority. You can type this into the fields in the app and they will generate in the document. So for instance, if the client has particular views or religious convictions about certain treatments, they can provide a limitation so that the agent cannot consent on their behalf. We recommend, like I said, not listing specific limitations, just really keep it to religious objections. So such as, I've had clients before that are Jehovah's Witnesses and they don't do blood transfusions. So that would be a good example of something like that. So a common question that we do get from clients is, if a first responder is killed in the line of duty, is an autopsy required? So because the healthcare power of attorney already includes authority relating to the consent to autopsy, some clients have chosen to add a statement about this because an autopsy is required. So work with your client to phrase the provision, but typically we put, I direct my healthcare agent to cooperate with requests for an autopsy if I am killed in the line of duty. So I'll say that one more time. I direct my healthcare agent to cooperate with requests for an autopsy if I am killed in the line of duty. So that would be a good phrase to put there just to ensure that we have that in there and everything will be complied with. All right, so we are on our final document, and that is the power of attorney. This deals with financial matters. So document overview, simply put, the power of attorney, also the client is called the principal in this document, designates an agent to make decisions concerning the principal's property on their behalf. So another term for agent that you may be familiar with is attorney in fact. The statutory form uses the word agent and it tends to be less confusing for the clients to call it an agent. So that's what we typically keep it to. The power of attorney we are doing through this program, as I stated at the beginning, is effective as of today once the client signs. We do not offer any alternatives to this. We understand that there are different powers of attorneys out there, such as a springing power of attorney. But for purposes of this program and our malpractice, we only offer the statutory form, which is effective today when the client signs it, or whenever they go get their documents signed. The statutory form is what we call durable. So this means the document is not affected by the principal's incapacity. So if the principal loses capacity, the POA stays in effect. So essentially, once the document is signed, it's effective until the client, our client, passes away. And then that's when the will goes into effect. So key explanations for the client. So a big key difference that is important to highlight for the client, the durable power of attorney can be used by the agent and the client simultaneously, even as the client can make decisions, even if the client can make decisions on their own. So for example, if I execute a power of attorney naming my sister as my agent, my sister can make banking transactions for me, or she can speak to my personal creditors on my behalf, even if I am fully capable of doing that myself. While there is nothing inherently risky about this, it highlights how the powers under the power of attorney are, and to make sure that when the client is naming an agent, they trust this person. It's very similar to the trustee in the will. You want to make sure that this person is going to act on your behalf, your best wishes, and make sure that they're good with money and they're not going to do anything that you wouldn't do. All right, so some more key information. The power of attorney document grants a wide range of powers to the agent. These powers are divided into two groups. So we have the general authority and we have the specific authority. The general authorities are the things that people tend to think of when they think of financial decisions that they make in their life. So the general authorities could be real property, so it's like a house, tangible personal property, a car, stocks and bonds, commodities, options, banking and financial institutions, operation of an entity or business if a client owns a business, insurance and annuities, life insurance, estates, trust, or other beneficial interests, claims and litigation, personal and family maintenance, governmental programs, retirement plans, and even taxes. Your agent can pay and file your taxes for you. Unless the client has a specific reservation about granting some of these authorities, you can advise the client that they have the ability to just grant all of them. The specific authorities are set apart in their own section because of the potential for fraud or misuse by the agent. The specific authorities allow the agent to make a gift, create or change right or survivorship accounts, create or change beneficiary designations, authorize another person to exercise the authority granted under the power of attorney, waive the principal's right to a beneficiary of a joint or survivor annuity, it also includes exercising fiduciary powers that the principal has the authority to delegate, and disclaim or refuse an interest in property. It also includes the access of electronic communication. So that could be like an email address. There's also an option for the principal to allow the agent to exercise specific authority, even if it stands to benefit the agent. So that can be kind of confusing. I'll give you an example. So if the agent is my sister, and I always give my sister $100 at Christmas, unless I give her the authority to benefit herself in my power of attorney, she cannot gift herself that $100 at Christmas acting as my agent. So a more consequential example could be if my sister is my agent and we jointly inherit our parents' house when they die, my sister cannot disclaim my interest in the property acting as my agent unless I have given her the authority in my power of attorney. So often the client is naming an agent that they trust outright and will often choose to grant all the specific authorities. So just make sure that you're explaining and you're able to make sure that the client is making an informed decision. So as we talked about, this is a durable power of attorney and is therefore going to be effective immediately. The power of attorney remains in effect, like I said earlier, until the client passes away or revokes the document. Since our clients are likely getting wills at this clinic, it is very important to emphasize that the power of attorneys do terminate at death, and this is kind of what I explained earlier, that once they do pass away, the will is what goes into effect. And then also, like the healthcare power of attorney, divorce does not revoke the authority of a spouse named under the power of attorney. So if they do get divorced, we want to make sure that they're getting new documents. So what are the agent's duties? The agent does not have an affirmative duty to exercise the powers granted. However, if they do exercise the power, there is a standard of care. The agent must act in the principal's best interest and in good faith with care, competence, and diligence. They must not create conflicts of interest that impair their ability to act on behalf of the client. Additionally, they should keep a record of all receipts and transactions. At the estate point, if someone passes away and you're acting as their agent, if you have receipts of transactions, it does help with that. It also just helps verify that you were acting in the best interest of the client as well. There is going to be a 2-page informational sheet about the agent's standard of care that is included with the power of attorney document. So some practice notes: review all of the general authorities with the client. If they are comfortable with granting all of them, there's going to be an option in the app that allows you to do so. Otherwise, you need to walk through each general authority and then mark only the ones that they do not want. So emailing the documents: once you have completed the meeting, you will email us your documents. The information was provided to you today by Alex, and we just wanted to make sure that if there were any issues in the meeting that were not addressed while you were in the meeting, you do include that in the email so that when the attorneys are reviewing the documents in the afternoon, we're ensuring that we are meeting the client's wishes and all the issues have been addressed. So the key points to just take away from this: that was emailing documents. And then the key points, just make sure, don't change the documents. They are what they are. We're here to help first responders and just have fun. Thank you.
Okay, I'm going to share my screen again and go over the app briefly. Okay, so the Wills for Heroes app. You should be seeing a couple of screenshots of the app It's a web-based document production application. It's designed to be easy to use for any attorney, even if you have little or no experience with the 3 documents that Samantha reviewed. The app contains a suggested script. It contains practice notes to you explaining the key points, and it has fields to enter the client's information. The clients were asked to fill out a questionnaire prior to this clinic, and the questionnaire tracks with the app. Although there's not a lot of information to enter, do take your time and counsel the client as they make these important decisions. The information you enter saves as you proceed forward in the app, and there's a back button if you need to return to a section. The entire session is also saved within the app, and you can navigate back to that session if you need to. At the conclusion of the interview, the documents will be automatically generated and be available for you to download. Be sure to read the instructions on the last page carefully as they pertain to finalizing the documents. Many of the clients that we serve are married couples. In the app, you will first complete all of spouse A's documents. When you move on to spouse B's documents, there's a question asking if the spouse's documents have already been completed in the same session. You can see an example of this in the second screenshot. It's this last question that's shown. By selecting yes here and choosing spouse A's name, all of spouse A's appointees will become selectable in spouse B's documents. We have found that couples will often name the same handful of trusted family members to serve as agents, executors, trustees, and guardians. And this function of the app is designed to reduce your need to type the same names and addresses over and over again, which also reduces the possibility of entry errors. If spouse A's name doesn't appear, try opening the app in a new window. One technical note: on the list of selections from spouse A's agents, there will be a set of parentheses next to the name stating which role that name is associated with in spouse A's documents. For instance, if spouse A names Sarah Sibling as a healthcare agent, durable power of attorney agent, and executor, Sarah Sibling will appear 3 times on the list with those roles listed next to her name. If spouse B wants to name Sarah Sibling as a healthcare agent as well, it's helpful to select the Sarah Sibling from the list that aligns with that role. This is because the app pulls different data from the various documents. So if you selected Sarah Sibling with the executor role within the healthcare power of attorney, Sarah Sibling's address would not automatically fill in because no address was entered related to her appointment in spouse A's will as executor. Likewise, if you select Sarah Sibling with the healthcare agent role under executor for spouse B's will, Sarah Sibling's sex will not automatically fill in because no sex is associated with the data for healthcare agent. There's nothing wrong with selecting a different role from the list. Nothing bad will happen, but you may just have to fill in some additional information. This feature is optimized for your convenience. If you can select a previously named appointee within the same role for the autofill purposes of the app. All right, practice notes. So we encourage you to exchange phone numbers with the client right at the start of the meeting. Then for some reason, the Zoom goes down or the 2 of you are disconnected, you can connect by phone to finish the app script and interview and finalize the document production. There are a number of fields in the app that are required, and the app will not advance if a value is not entered for those fields. Of course, sometimes a client needs to go search some piece of information out. We try to prevent that with the questionnaire, but it happens. So if they don't have the information and they don't want to hold things up and want to move forward, you will enter a placeholder word in all caps that alerts the still needed information. For example, if the client is missing an address, type in address in all caps in the space. When the final documents are produced, the client can either go and find that information so you can edit it in the app directly in the document, or you can send that draft to the Wills for HERA email, the wfh@ncba.org, with a note that an address or whatever missing piece of information is still needed, and then instruct the client to bring that info with them when they go to pick up their documents on site. We are able to edit the documents on site and print new copies, so that's not a problem. If there's anything else that you think we should know about the client's circumstances or documents prior to having the client sign the documents, please also include that in the information that you email to the Wills for HERA's email address. And finally, before concluding your call with your client, please cover instructions for the in-person notary clinic. The notary session will take about 30 minutes, and the information for your various clinic will be provided to you prior to that first client meeting. Okay. All right, well, that brings us to the end of our volunteer training. We can't thank you enough for volunteering to provide these essential legal services to pro bono clients. Wills for Heroes truly could not exist without all of you. So many thanks from all of us at the North Carolina Bar Foundation.